Hi, I'm Mark Springfield, founder and partner in Springfield Collaborative Divorce.
Hi, I'm Dr. Brian Mackey, a child psychologist, and I am the voice of your child in this process.
Hi, I'm Kerry Burleigh, law partner at Springfield Collaborative Divorce.
A common question I get from folks thinking about the agonizing decision to separate and divorce is this: I'd really like to use the collaborative method and avoid the court process, but I just don't think my spouse can be collaborative. Can I really avoid the drama? And my answer is typically yes. There's not an expectation that couples themselves, particularly at the initial stages of divorce, will be collaborative. This reveals a common misunderstanding about who can benefit from collaborative law and what collaborative law means. Collaborative law started about 20 years ago when a Minnesota divorce lawyer named Stu Webb became exasperated with what his divorce practice and the court system were doing to families. He brought together a small group of lawyers who agreed that they would make a contract with their clients to help them negotiate a good agreement and keep them out of court. These lawyers agreed that they would help their clients problem solve instead of engage in adversarial negotiations, and that other specialists, like child psychologists and financial planners, would be used differently and more effectively to help families make a healthy transition. So in reality, it's not so much that couples must be collaborative, it's really about how the attorneys behave. At Springfield Collaborative Divorce, there's a clear expectation that the attorneys using the collaborative method will help to reduce and not make worse the drama so often associated with divorce.
You might be wondering what we mean when we say divorce without drama. Clearly, there is a lot of emotion involved in divorce and separation. And when we say divorce without drama, we don't mean that there aren't difficult legal, financial, and emotional decisions to make. What we do mean is that in a collaborative divorce, we as attorneys operate in a manner that does not add to or escalate the drama. For example, an attorney in an adversarial process might advise a client who is requesting advice to withdraw all the money from joint accounts, change the locks on the door, or perhaps limit or withhold access to the children. This kind of advice is what adds to the drama of an already difficult and scary situation and can make reaching a resolution even more problematic than it was to begin with. In contrast, when people are using a collaborative method, they agree not to take any preemptive actions which would sabotage the other person. With protections of a collaborative method, separating spouses are not reduced to destructively tearing apart their old lives, depleting financial and emotional resources. By choosing the collaborative method, our clients can begin building their new lives right away and with less drama.
As a mental health professional, I've spent the better part of my career helping to repair the damage and mistrust caused when drama overtakes a family going through a divorce. It's well established that the intense stress, confusion, and conflict often present in methods of traditional divorce can have a substantial impact on children's short and long-term mental health. The collaborative method, our method, offers an alternative to this path for your children. In this method, parents, who are the people who know and understand their children best, make all of the decisions for their children's future, rather than lawyers, judges, or custody evaluators. In our process, your team of professionals is specifically trained and motivated to act in the best interest of your entire family, especially your children. Your team is here to help you problem solve, freeing up more of your time and energy to focus on your children. What I see in our method of divorce are parents who feel more confident and empowered. We teach the skills necessary to have difficult conversations and to advocate for your needs while listening to those of your spouse. These parents make outstanding role models for their children when it comes to handling conflict and family tension. The skills they learn help their relationship with their co-parent and their child for life. Without the drama so often typical of traditional divorce methods, our method gives the families we work with the very best opportunity for a healthy, happy future in two households.
In the 20 years since Stu Webb coined the term collaborative law, thousands and thousands of divorce lawyers across the country have taken collaborative law trainings, and thousands of collaborative cases have been successfully resolved. In North Carolina, the state legislature passed a law in 2003 codifying collaborative law and making it part of the family law statutes. Unfortunately, there are many lawyers who say they offer collaborative law services in North Carolina, even though they have traditional court-oriented law firms, and even though they seldom actually have cases in which they follow the statutes that govern the collaborative method. Divorce without drama is a lofty goal, but it's a goal we take very seriously at Springfield Collaborative Divorce. We only accept cases in which the couple has decided to proceed using the collaborative method.
Mark and I both made the choice to only accept cases using the collaborative method because we are convinced that this method is the best way to help our clients make the difficult transition of divorce. We have experience representing people in hundreds of collaborative cases. Even in emotionally charged cases, we navigate the legal pitfalls and emotional hurdles common in divorce. We are passionate about this approach to reaching a divorce settlement. It encourages cooperation instead of confrontation, and it creates an environment where a couple can divorce with dignity and display respect, integrity, and kindness toward each other.